All right. Hi, this is Attorney Betzold, once again, your host of the Prima podcast, where we delve into legal discussions with legal experts. So what we've been doing is putting together this show where we interview attorneys. Right now we're dealing with immigration attorneys who've taken or who are taking or want to take more cases to federal court. And so today, in this episode, we're talking with attorney Carrie Pastor. So, Caridad Pastor Cardinale, for those who speak the Spanish. But attorney Carrie Pastor is from Troy, Michigan, where she has her practice. She has a lot of experience, 30 plus years of experience in practicing immigration and taking cases to federal court, and also establishing a favorable precedent here in the Sixth Circuit, which states that if the USCIS interviews your client, then they have the 120 days to issue the decision in the case. I believe that's what we said. It was 120 days. I have to go back and listen to be sure. You're going to know real soon because you're going to listen to the episode. But what has been happening is USCIS they had been doing the interview, then delaying a decision, saying that that time should not have started for whatever nonsense reason they gave. So thank you to attorney Carrie Pastor for joining us and discussing that in depth as we delve into the topics of federal court. And the show today, as always, is brought to you by Prima Facie. So Prima Facie is the immigration attorney, the immigration professional's preferred choice for autofilling your forms, managing your caseload, and generating that final package, that final product that you need to submit to USCIS, to the Department of Labor, to EOIR, Immigration Court. And I know if you're an immigration attorney, you've had a situation where you fill out the forms, you're reviewing it with the client, and the client says, you spelled my name wrong. Or you realize that the name on their birth certificate is not the name that they've been using or when they dealt with your office. So you need to make some sort of global change that normally would take a long time, but if you're using Prima, you make it in one place, you tell it to update, and you can go ahead and print those forms again. And of course, then when you're generating that final package, I was just doing this the other day, right? So we've got this asylum case, and we're preparing our supplemental exhibits because it looks like they're going to be holding the individual hearing soon. And so we're gathering country conditions, gathering extra exhibits, anything else that we want to support our client's case with. And it's always a real pain because you have to create a table of contents, so you want your exhibit numbers, you want the description, and you want page numbers for how long each exhibit is. Well, doing that by hand is just a bear. Doing it with Adobe Acrobat alone is a manual process. It takes forever. And then what happens when, like with me, you add some exhibits, you run it all in, then you realize, that exhibit's 300 pages long. That's a little excessive. Well, then you got to go redo all that stuff. Well, we've automated that with our package assembly product, with our package assembly feature inside Prima Facie. So it's drag and drop. You upload your documents, you drag them in the order you want them to appear in the exhibit list, you generate the table of contents, it adds the page numbers, you render that PDF, you download it, you print it, or email it to the court, and you are good to go. You can find a free 15-day trial at primafacinow.com, primafacieNow.com. And we hope you enjoy the show today. Thanks for sticking with us. And again, special thanks to attorney Carrie Pastor. Bye-bye. Hello, I'm attorney James Betzold. Welcome back to the podcast. I am joined today by attorney Carrie Pastor from Troy, Michigan. Carrie, welcome to the show.
Thank you, James. I'm happy to be here.
Awesome. So, Carrie, tell us a little bit about yourself. What's your story? Like, where'd you go to law school? What was your first job out of law school? Where do we start?
I went to NYU Law School, and my first job out of law school was actually here in Michigan out of the Archdiocese of Detroit, where I was director of migration, and that included a legal clinic, an immigration legal clinic. And it was kind of interesting times because it was right during that amnesty period. So they used to have qualifying entities, which are known as QEs. And the Archdiocese had people that were certified doing that. And then those became, a lot of them became EOIR cases. And so they needed attorneys to handle that. So I was brought in, and then I brought in other attorneys.
Okay. So at the Archdiocese, you handled mostly asylum cases in removal court or in immigration court?
Yeah, cancellation of removal. We really had a variety. That's the fun part about working for a nonprofit. You never know what walks through the door. So I had a lot of good cases, and also I had some federal cases there.
Oh, really?
Hmm.
What kind of federal cases were you able to
So
take there?
so appeals at the Sixth Circuit, which happens, as you know, when the BIA is denied. And I also filed at the time some habeases, mandamuses for delays, application adjudication delays.
Oh, that's so cool that like at your first out of law school job, you get all that experience. I mean, that like there's some of us who wandered into federal court like in some related criminal cases or things like that. But wow, to have that experience right away, that's fantastic.
Well, when you start out, you don't realize how much you don't know, right? So I thought, yeah, sure, I can do that.
Federal court, no problem. Let's walk in. It's
Right.
probably the way that I walked into immigration court.
Okay.
Ignorant. Okay, so Archdiocese, got some cases under your belt there, experience there. What happened next in your career then?
Then I burned out, as happens sometimes in nonprofits, just because of the sad stories and the caseload and all of that. So I got hired by Butts Along. And at Butts Along, I assisted another attorney with some employment-based cases, but I also continued to do EOIR cases.
Okay. So what type of employment cases did you handle there?
The other attorney used to do a lot of L's, so that's what I used to help her with.
Oh, okay. And just for people who might not know, L visa is that's like an intra-company transferee.
Yes.
Okay, so someone from a company that has a place in two countries and they're transferring employees to a place at the other country.
Right. Exactly.
So we must, I mean, and you're located in Troy, so that's like right near the border with Canada. There must be a fair amount of that type of casework.
Yeah, there were some TNs, but I don't recall actually working on those in but so long. I have done those when I've been on my own, since I started my firm. But there is quite a bit, and that there's also waivers people need to come into the country from Canada if they've had any convictions. So I've worked on those too.
Oh, okay. And so how long have you been practicing immigration law?
So it will be 30 years in this June.
Oh, congratulations. That's an awesome anniversary to have.
Thank
And
you.
you're still practicing immigration law because
Right.
yes, burnout is real.
Right. Very true.
I think part of it is people want, they come to the lawyer and they're like, hey, can you help me? Can you essentially save me, or in asylum cases, prevent me from going to somewhere where I'm going to be murdered or beaten or subjugated or put into what's effectively slavery? And when you can, it's great. And that works out and that sort of builds you up for the next one. But then when the case doesn't go as hoped, or the attorney general comes out and says, oh, we're not going to do those anymore. We're going to take that off the table. If you want to try that, good luck. That can be quite frustrating.
Yes.
And not just frustrating. I mean, it's like, it can be traumatic for the attorney who's like, I was supposed to be able to save this person, and now there's nothing I can do.
There's definitely an emotional toll in this practice. Absolutely. It's a very personal type of practice. A lot of responsibilities placed on the attorney, and it's usually not only the specific person that may have removal proceedings, against them, but it's also their family.
Yeah.
And so
And it seems like there's just a lot of, for example, in the cancellation of removal cases where you need to prove an extreme hardship to the qualifying relative, and you've got all this hardship and it's real and it is extreme, but there's some precedent case out there and maybe a judge who says, yeah, it's extreme, but it's not extreme and unusual. It's extreme, but everybody has the extreme hard. You need it unusual as well. And this isn't quite unusual. So the whole case tanks maybe on that, at least at the trial level.
Well, yes, and that's what federal court's for, right?
Right, which is why we have to start going to federal court more and appealing those things. So so you have your own practice now?
Yes.
When did you open your own practice?
in 2000.
Okay,
So
good. So
20
tell
years.
us a little about that. What was it like opening up your own firm?
A bit scary because you never know if anybody's going to walk through that door. You have to pay rent. I started without a staff. I did everything myself. And as I grew, I added a receptionist and then added paralegals and then more lawyers. So, but it is scary. A lot of responsibility, especially the more people you add on, the more responsibility.
Yeah, it can be intimidating. And I remember, I mean, just in the early days when we opened our firm, it was like, I don't know, how are we going to get rent for next month?
Right?
Let's do this. Let's do that. Yeah, it's fun. Being a business owner is, you can spend a lot of time just being the business owner and
Yes.
then needing the attorney as well. But you have other attorneys that work for you now at this point, right?
Yes, I do.
Okay. So you've got your own firm, got your own attorneys working. I mean, it's working out. Yes.
Yes, it is.
Yeah.
And I'm doing something that I love. So it's a win-win all around.
Perfect. Great. So tell us, what are some of I mean, we mentioned about these federal cases that we need to start taking more of, and it's becoming more and more necessary to do that just because we're getting ridiculous denials for silly reasons, or because of the attorney general, or because an administrative policy. Which ones are your favorites?
My favorites are basically the complex ones that require a lot of how do I put it? Connecting pieces together, like putting the puzzle together to achieve the result you want. So those are my favorite. I don't like if it's a straight up, you just go into a complaint and it's going to get settled and blah. I want to have some issues.
You want the fight. You want the
Yes.
litigation. You want.
Yeah. Yes. Yes.
Okay, good. No, that's definitely needed. So let's talk about one of the cases that you've handled where you had some really good success. Where do you want to start?
Well, the Chebli versus Chertoff is one of my favorite cases. And the reason that was a mandamus delay, but the reason it's one of my favorite cases is that in that case, the judge did such a wonderfully strong opinion against what was then INS, which is now the equivalent of USCIS, and actually stated in his decision that my client had been waiting 1,310 days for his application to be adjudicated. So that was a wonderful decision. And after that decision was issued, he also acknowledged that only the court had jurisdiction once a mandamus is filed. Jurisdiction does not stay with USCIS. So it
So
was
complete jurisdiction over the naturalization application then.
Yes. So that's why I think that was a wonderful opinion.
Yeah, that seems like, I don't want to say counterintuitive because that's the way it is, but typically if you're appealing something and you go to an appeals court, the appeals court is usually like, yeah, we think they screwed up at the lower court. We're going to send it back to them with instructions this time.
Right.
Or they'll say, yeah, they were wrong. Do this. Or they give some sort of a remand, or they can just take a decision on it. But where jurisdiction actually switches on an N400, because typically with naturalization, you're thinking USCIS, we file it there.
Mm-hmm.
You can't file it in immigration court.
No.
Judge has no jurisdiction. Only USCIS does.
Right.
Unless there's a mandamus. So tell us a little bit about why the mandamus was necessary. What was going on in the case?
So basically I didn't see any issues when the client came in. And so that happens a lot of times where issues come up later. In this case, it didn't. It was a straight eligibility for the N400. He was definitely eligible. And the interview, as the judge noted, had passed over 1,000 days before. The government was arguing that the interview itself wasn't the interview meant in the statute, that in the statute, the 120 days was after everything that was collateral to the interview was done. In this case, FBI checks had not been completed. And that's what apparently was pending for over 1,000 days. Which of course then federal court is wonderful. You see miracles all the time. All of a sudden things get approved, things get done that should have been done. It's awesome. But anyways, that's what they argued. And so that
So they were saying that, oh, well, we didn't do the FBI background check. It's not complete yet. That was their
right.
argument.
So the interview is not complete because the statute doesn't mean like just the actual interview where you're facing the officer and answering questions. It means everything that's collateral to it, including the FBI checks. So that's what they were arguing. And the judge obviously said, no, interview means interview. And it's 120 days after he appeared before the officer. And that was great. And so now we have that case law in the Eastern District of Michigan. And we have a straight, it's 120 days after the actual physical examination of the client, not when everything else that needs to be done is done.
So why was it taking USCIS like over 1,000 days to complete a FBI background check? Because typically you get your fingerprints, they get sent to the FBI reviews it against the database, and it's done. And it's usually a matter of months normally, right?
Right. Back in those days, before these cases, I saw a lot of delays of several years. It was not uncommon. And every time I'd do an inquiry, it'd be the FBI checks. They're not in, they're pending. So you have to wait for those. So that was just kind of common. It's not now, but it was back then.
Yeah. So, 2007, so this few years post 9/11, were there any additional screenings that that USCIS was saying that they were going to subject your client to, maybe because of his background, anything like that?
I think part of the delay was, and they never said that, but I think part of the delay also had to do from the fact that my client was from the Middle East. And those background checks, I think they either wanted to do more of them or for whatever reason. We were never told.
Yeah, and that's usually the biggest thing, right? Client comes and says, "Hey, my case is pending. What's going on? You're an attorney. Why don't you tell me?" And the answer is, "Wait, I guess."
Right.
Let's write a letter to them and see if they answer. They're not going to answer,
No, of course, but it's good to do all that, actually, now that you bring up that point, so that when you get into federal court, you can at least show the judge how many times you've tried to get the relief you wanted, and how there was either no response, or in this case, in the Chebli case, they would respond back saying the FBI checks are pending. And so I think we did that several times, about 3 or 4, and got that back, and then we went to federal court.
So you can sort of show that record of, look, judge, we were trying to be reasonable. We were trying to just go through everything that we could. We, can't call except the 800 number and you get nothing. And then you just wait on hold forever. But we sent an email. We did this, we did that, the other thing. And look, they're just being unreasonable.
Exactly.
Yeah. Exactly. So, that was, post 9/11 and really, I think 2007 and on, and even still today, eventually you run into these clients where if they're from the Middle East, the government is just ridiculously delaying their case.
Right.
And they're saying, well, we're doing, what was it the president called it? Extreme vetting.
Extreme vetting.
And what does extreme vetting mean? There's nothing different about the vetting they were doing before.
Well, it's one of those things that happens, that extreme vetting is undefined, and things are delayed. And what I found is when you push them, they'll go ahead and deny the person on some vague ground of giving some support to some terrorist organization, and don't really have any backup for that. So currently I have in the District of Maryland, I have a watch list case pending with CARE. And I also have one in the Sixth Circuit where the person was not granted an immigrant visa. It had been pending for years when they came to me. And so once we filed in court, they issued a decision saying that, they thought he provided material support, which is completely not true. And so the district judge granted the government's summary on a basis which I don't think he was really clear, because the government never explained why. Their position was that they didn't have to explain anything, that it's consular non-reviewability. And of course, my argument was that no, it's agency reviewability, because the agencies are making this determination. And so now it's before the Sixth Circuit, and we had oral arguments a couple of months ago, and wait and see what happens. And hopefully he can be reunited with his family. The one that I'm co-counseling with CARE in Maryland was a gentleman. And both of these clients are from the Middle East. A gentleman who would come in on his ESTA. The visa, ESTA is the visa waiver, where you come in, you can't stay any longer than 90 days, but you don't need to go and apply for an actual visa. So he had been denied that after using it for several years to visit his children who live here. Has no interest in migrating here. Had no problems for years. And then all of a sudden, about 2 years ago, they just started denying every time he applied. And the good news on that one is that while the case is pending, he's the lead plaintiff. So while the case is pending, they mooted him out. He just got his visa. Actually, he emailed me today that he just got it. So that's nice. And the government does try, when you have a class action, they do try to moot out your lead plaintiffs, your named plaintiffs. So we got the result that we wanted without doing much other than responding to a motion to dismiss.
Okay, so for that one, but that wasn't filed as a class action, or it was?
That one, the one in Maryland, was filed as a class action with CARE.
Okay.
So, yes.
So what happens to the rest of the class then?
They continue.
Do they handle those like individually, or?
They as long as they remain with no relief, then the argument becomes that you may have mooted this person out, but there's still other people that are affected.
So you just substitute in a new lead plaintiff from the pool of current plaintiffs, and
right.
Case goes forward.
And or continue with your other, because when you do a class, you name, like, I think we named 28 plaintiffs.
Yeah.
So, he may be mooted out, but there's 27 more.
There's still more people suffering from it. So
absolutely.
Okay. That's so cool. So this case with the N400 in the Eastern District of Michigan, Chebli, is that how it's pronounced?
Chebli.
Chebli. Okay.
Yeah.
I'll put the link to that in the description of the podcast here, so people can link to that as well. But yeah, it's a reported decision. So when the judge said, no, we're going to deny the government's motion to terminate because 120 days means from the interview, just like every other or most other districts.
Right. The plain meaning of the language in the statute is the interview, when you sit down with the other person and you answer questions.
Right. Otherwise, that would just let the government delay everything forever if they wanted to, right?
Exactly.
So they could say, well, FBI check's not done. We didn't finish it. We didn't certify.
Right. 10 years later, they still haven't finished it and the client's waiting.
Right. So after that, the judge, he has the power then, I guess, to grant the naturalization?
Right. So in this case, even though the judge said they had no jurisdiction, USCIS went and granted the naturalization.
Okay.
And so at that point, it became, do I go back in and say, no, they never had jurisdiction to grant this, you should do it, Your Honor? Or do I just say, okay, they granted it, it's valid, we're done? And for the sake of the client who just wanted the result, we just did a joint motion to dismiss at that point.
Okay.
Mm-hmm.
Yeah. If, let's suppose that they hold a hearing, and this is just pure curiosity on my part.
Mm-hmm.
Let's say at the hearing on the motion to dismiss, if the judge holds a hearing and says, you know what, I'm denying the motion to dismiss, I'm granting U.S. citizenship, put your arm up, we're taking the oath right now. Can he do that?
He can deny the motion to dismiss, and yes, he can do that. Normally, though, another day is scheduled for the naturalization.
Boy, in the Hollywood version of this case, they're doing it all in the same hearing.
Right. Right.
That would be fun. Okay, so what other issues have you seen with N400s? Are there other? Well, let me go back a little further.
Mm-hmm.
When you filed the case, so the client came to you, his N400 had already been pending. Is that right?
Right.
Okay. So this has been pending a long time. Want this done. Judge says, yeah, it's 1,000 days. When you decided to file the case, were there multiple statutes that you looked at to sue under, or was it clearly just a straight up mandamus case that you needed? How
okay. So I always remember the wise words of the late Chief Judge Julian Cook in the Eastern District. And he told me early on, because they have an excellent new lawyers training in the Eastern District. And he told me that when I attended that in 1990, he told me, always remember that it takes 10 years to make your reputation in federal court and 10 seconds to completely destroy it. So when I file something in federal court, I'm going to be thorough. I'm going to do a lot of research, see what statutes apply. I cite case law in the complaint. If exhibits, like in this case, we had contacted USCIS, so exhibits are put in, whatever needs to be done to make it as strong as possible, because the government's always going to move to dismiss, always. So you want to make that complaint strong. And even though you have a chance to respond to the dismissal, you still want to make that complaint as strong as possible. And a nice little tip that another lawyer taught me is that you have a chance to amend your complaint. So you can use that chance after the motion to dismiss is filed in order to fix anything that the government may have brought up. And then, you can respond to them. Usually the judges at that point say, well, okay, now we have to do another motion or another response or something like that. So that's a good way of, I think, correcting anything that the government might bring up in your complaint. But I try to do as thorough a complaint as possible.
So then it was a mandamus case.
Yes, it was.
So it wasn't brought under the APA. It was because they have to take the decision after the 120 days. So you can file to say, judge, make them make the decision, or you make it, right?
Right. And the judge has authority to naturalize. So that's what's kind of nice about the N-400 mandamus, is that you can always request for the judge to do it in your mandamus, which is what we did.
Nice.
We didn't want to remand it back to USCIS because who knows how long that's going to take unless the judge puts a deadline on it. So, so that's kind of nice that, we don't have that clear cut instructions in other types of cases. In other types of cases, all the judge can do is issue an opinion and provide a time by which something has to be done.
I see. Yeah. Wouldn't it be neat, though, if the federal judge all of a sudden had authority to grant like a disputed I-130 or a removal case?
Right. So I have brought I-130 mandamus pending. And those are a little harder in the Eastern District because there's no bright line as to what is reasonable. Try to use the 180 days. But I've gotten some judges to say, yeah, they have to do it by such and such a date. And I've gotten other judges to say, no, they can take as long as they want. So always you want to try to settle, And in that particular I-130, we settled. I had an immigrant visa fiance visa that was delayed for a really long time. We brought that one in, that was settled. So the majority of the cases do settle. Though lately I've been seeing the government fight everything because it's just a different world we live in right now.
Yeah. All right. So online in like the different attorney groups, on Facebook and whatnot, has that helped you at all in your practice recently?
Oh, absolutely. One mind alone can't practice law. And that I was taught at NYU. Any kind of area that you're in has to be practiced by multiple lawyers together. So there should always be cooperation. So yes, the different listservs as well as the Facebook groups, discussing it with other lawyers that are, more senior than I am and have been through much more, is standard practice and very, very helpful.
Yeah, one of the things I've seen is, I think it was probably, 4 or 5 years ago, I was introduced to the world of the attorney group, the private and secret attorney groups on Facebook, right? And it really changed my practice. I mean, just the different perspective that other attorneys bring, who've got more experience than I do, or maybe more experience at a particular case type than I do.
Exactly.
And I think what we've seen recently is, because we're getting so many crazy things that are happening, because like you said, the government's fighting everything, and it's not just at the federal court level, but it's with USCIS on filing a family petition, which should be straightforward. Or if there's, if you have like an Adam Walsh case which are very routinely, it seems, denied. You need to get to a third party who has authority, who can say, wait. Let's look at this again. Here's the evidence. Here's what you did.
Right.
Here's how they responded. Or, I mean, I can, just from my own caseload, I can look and I can say, hey, we filed this 290B, let's say, with the Vermont Service Center, and they send it back saying, oh, we don't have jurisdiction. It's denied. And you look at your mail and you're like, wait a minute, I sent it to the right place. It was titled correctly, but then they transferred it to a different service center that doesn't have jurisdiction. And now they're denying it because they say they don't have jurisdiction. They say it's my fault. And the client's been waiting 5 years.
Exactly.
And now what?
Right. And it's so frustrating. And that's what that's why we have federal courts, to deal with those kinds of issues. And sometimes they can seem minute, but they're not. When, you have a life at the end of that line that's waiting for either to have some stability in the country, as you say, not being sent back to a country where conditions are terrible, or just reuniting with the family.
Yeah.
So, right. So even though we think, oh, well, I'll just remail it, and you've done that a couple of times and and you think, oh, I'll just keep doing it. No, that's what federal court's for.
Yeah. And I mean, especially if it's a petition where it could take 10 years or 15 years now due to wait times. I mean, refiling is just, how do you tell someone we're just going to try refiling it instead? It's tough. So I think that's a huge trend in the practice of immigration. I think more and more immigration attorneys need to become admitted to the federal bar in the different jurisdictions, need to be aware of the different types of cases that we can take, and to know that, if you take that case, there's a fighting chance you win, and it's a good fighting chance.
Absolutely. Because you're getting it out of the system that I believe is stacked against the immigrants or non-immigrants, and you're putting it into the hands of a truly neutral arbitrator, someone who doesn't deal with immigration all the time, but deals with other types of cases. And so they're looking at this from a very neutral standpoint, is what I find with federal judges. And they're looking at the law, the equities, and then they're making the decisions.
And I think there's so many times where, I've only been practicing immigration a decade, only 10 years, 11 actually now.
Congratulations.
So, but great. When I first started, it was like, you know what? There's a statute and it says this, and this seems pretty clear. And then there's a regulation and it's like, okay, that seems fairly straightforward. It maybe it's a reasonable interpretation of implementing the statute. But then you get these policy memorandums where USCIS can just rattle off a new policy and say, oh, we're going to do it like this now. And then they update their practice manual, which it just happens willy-nilly. And don't even get me started on the forms, how often they want to update those. And
I know.
Change the instructions. And it's like you're trying to hit a moving target. And it appears, on the outside looking in, that when you put all that information in front of a judge, you say, look, let's go back to what the statute really says here. And now let's go back to what the regulations, which either are legitimate or maybe they're ultra vires, maybe they're outside the statute and they never should have been implemented to begin with, say.
Yeah, and I find that happens quite a bit. And so that issue is always resolved in the district courts if the regulations ultra vires. Again, it's very common for them to settle and give you the relief they want. I think partly because they don't want bad law out there. I have had cases where I actually had one in the Sixth Circuit where the oil attorney called me and said, I'm going to call the ICE attorney and tell him to just join a remand, have it remanded back, and let's do your client's case, because they didn't want a bad opinion. No one notified the judge that was happening. And a good decision was issued, which was published, pretty much slamming EOIR and USCIS. And then the attorney called, all bent out of shape. Nobody told the judge. I said, well, you were the one that was going to handle the remand. Well, nobody told me that the remand had been granted. I said, well, you need to talk to Chief Counsel's office for that. So
They won't
he
return my
then,
phone calls, and they're really mean to me. I don't want to call them.
right, right, exactly, exactly. So then, and that does happen too, that's another funny story, another federal court case in which that happened. But so the decision was out. So then he asked me if I would join a motion to have the decision unpublished, and I of course said no. So he filed it on his own, and that was another great decision from the Sixth Circuit about, like, are you kidding me? Right. So those, I mean, that was a lot of fun.
Wow. That's so cool. I think it's so great to hear these stories, just to hear, the successes that you can have if you can get up the courage, do a little bit of do a lot of research. It's not a little bit
A
of
lot.
research. I mean, when you, like you said, when you wander into federal court, you need to make your reputation, and you can destroy it really easily. And it's a different world, right? What's it like?
Totally.
Let me just ask you. I know what I think. What's it like dealing with the AUSA's office? So the federal prosecutor for the USA, compared to trying to talk to an ICE attorney.
It's a completely different world. Completely different world. I mean, you're talking about, being in paradise, basically, when you compare it, when you go to federal court, because the AUSAs are very practical. And, there are some that are going to defend whatever ICE or USCIS did to the hilt, but they'll be very professional. There's always a line of communication. They always provide their cell phones, so that we're able to talk to each other if we're out of the office. Emails constantly. And it's just completely different. I mean, you can talk some sense into it. I had a case recently for somebody to be released from ICE detention because of the COVID-19. And so I went to federal court with that. And the U.S. attorney and I had wonderful contact. I had another case years ago together. And he argued strongly for his client, but we were talking all throughout it. And, and what are you thinking? Can we do this instead? Can we do that instead? Can we agree to this? It's an open channel I've found with every U.S. attorney, assistant U.S. attorney that I've worked with.
Yeah, I've seen the same thing. So we had this is a fun story. I got to save the full story for another time.
Right.
Essentially, there's a U visa case, and because of what happened in the U visa case that the guy was a victim of, they end up getting medical treatment with a social security number that didn't exist, and they end up in federal court for identity fraud, right?
Yeah.
That's literally the universe conspiring against you in the worst sense.
Yes.
And I mean, when we were dealing with the federal prosecutor there, it was like, oh, well, can your guy plead to this? I said, look, I mean, he can plead to it, but I don't think he honestly believes that. I was like, but you know what? It's a good deal for this, for that, whatever. And we get to the plea hearing, and in federal court, it is not like state court where it's like, all right, how do you want to plead? Guilty. Okay, good. You're guilty. Next, go pay your fine.
Not at all.
Whatever. No.
Like,
are you really guilty? Like, what did you do that made you guilty?
Right.
It says here you did A, B, and C. Did you really do A, B, and C? Tell me about it. Why did you do it? Well, when they get to there and your client says, no, I mean, I'll plead guilty, but I didn't do that. The judges are there are like, sorry, I can't accept your plea. We're going to have to go forward with the trial because you're not actually guilty and you're not admitting it. So I can't accept it. Which was mind-blowing because then we go out in the hall and we're talking with the prosecutor. Prosecutor's like, okay, you know what? I didn't realize it was quite like that. Let's do this other thing instead. Can he do this? Can he do that?
Exactly.
And it's a real court.
It is. And the judges are amazing in terms of protecting the client's due process rights, which we don't see in EOIR. At all. And I know when I've had to put a settlement on the record, the client has to be there. They have to, as you said, say exactly what they did. And then at the end, the judge always asks, are you happy with your attorney? Do you think they provided competent representation? Just to make sure that everything's been covered. And and that's awesome, because the client answers everything. They also provide a translator, if you need one for the client, which is also very good and amazing.
But
and
also be very careful. Oh man.
Yeah. Very, very.
Because armas de fuego sounds a lot like alarmas de fuego.
Exactly.
firearms,
Exactly.
fire alarms. Do you have
Right.
any
Right.
fire alarms in your house? Yeah, I got one in the kitchen. I got one in the
Right.
bedroom. I've got a firearm in the kitchen and in the bedroom.
Right, right, exactly. But
Jeez.
the nice thing about that, unlike immigration court, is that in federal court, you can say no, the translation, blah, blah, blah. Whereas in immigration court, they're like, no, he probably does have firearms. It's like automatic assumption without any basis. And you don't get that in federal court. You get a lot more fairness, a lot more balance.
So you're fluent in some other languages as well, yes?
Yes, yeah. So my parents are from Cuba, so I learned how to speak Spanish from birth. I also speak Italian, and I understand and can speak a little Portuguese. Understand very little Albanian, can't speak it, and I'm actually trying to learn Arabic now, so
Oh,
I
all
can
right.
communicate better with my clients. Yeah.
So originally, your parents are from Cuba.
Yes, yes.
Okay, what part of Cuba?
So my mom's from Havana, and she actually came in 1954 with what is the equivalent of the perm process now,
Mm-hmm.
which wasn't so vigorous back then. So she came here to work. And my dad came in 59 during the revolution because he was Secret Service for the former president, and he applied for asylum and won. That was
Oh,
before the Cuban Adjustment Act. So
what a great part of your family history to have.
yes, yes. I
Family
think
history and world history. I mean,
true, true.
so in our software company for doing immigration software, we
Mhm.
have our lead developer is actually from Cuba as well, from Havana.
Oh, cool.
And his story is fantastic about how he was able to get permission to leave,
Yeah,
check
which is
things
not
out,
easy.
and then leave again
Right,
and escape the communist rule, where they literally go into your home and say, "Oh, you're living above your station. You shouldn't
right,
have a flat screen TV, and you shouldn't have a nice
right,
bicycle. We're taking
right.
them."
So I visit my family. Now that we can visit family, which is awesome. That's something President Obama did that was very restricted before. And I remember being at my aunt's house in Havana, and the Committee for the Defense of the Revolution, the CDR, would come and measure the rooms. And if she had extra rooms, then they would move people in, whether you
Ooh.
knew them or not. And I remember when I saw that, that was just amazing to me. It's like, I don't understand they're measuring. They're saying, oh, you got 2 extra bedrooms. We're going to move so and so in here. Yeah, it's a whole different world over there.
Oh man, that is tough. When was
Yes.
the last time that you've been able to visit Cuba?
The last time I went was about 3 years ago, and I haven't. My daughter's been clamoring to go back to see her cousins, but I haven't been back just because the schedule's been so busy here.
Oh yeah,
Mhm.
yeah. Now there were some things that President Trump did. I know, like I don't think cruise ships from the U.S. can go anymore.
I believe, yes, yeah,
Yeah. So when
that's
they could,
restricted.
my wife and I, we went, and there was a group of immigration attorneys from one of these groups that we all took the cruise to Cuba, right? And we
Ah,
actually
great.
learned about. I don't remember what we learned about. I think it was on a topic I just wasn't very familiar with, but it was at Che Guevara's boyhood home, which is up
Yes,
on the hill there,
all right,
next to the huge statue of Jesus overlooking Havana.
right,
Yeah.
exactly. Yeah,
So we
it's
got
a
to go and
different
see
world.
that. And yeah, it's stunning. Like some of the architecture, like of the Capitol building that they're still building.
Right.
Beautiful. Beautiful. I
Yes,
mean, it's like Washington, D.C. with palm trees, the Capitol
yes,
building.
it is. It is.
And but then you go around the corner and you sort of follow the coast there back to where the port is for the cruise ship, and all this beautiful old architecture, and it's crumbling, like
Yes.
crumbling inside. A lot of times people can't live there anymore.
Right, right.
It's just a
It's
shame. I
sad
mean,
because there are some
imagine what
beautiful things.
Airbnb could do if they were like giving carte blanche there,
You're right.
right? Some
Exactly.
investors
But
and Airbnb, it's like you'd have that place turned
oh
around in a
yeah,
jiffy. There'd be no sharing, forcing people to share rooms. They would be the opposite.
right, exactly. But
Well,
like
that's great that you still get to go back every now and then and stay in touch with family. And
yes, yes.
yeah, it's a different world. I mean, I remember we're sitting in the cruise ship, and you look out over Havana, and I, first of all, we loved it. The people there are fantastic, super nice, very glad to see you, treat you very well. Nothing bad to say about that. But looking at it, I thought, boy, this looks kind of like, I don't know, Afghanistan or Iraq from the
Yeah,
harbor.
yes.
Um,
When you get to see the real Cuba.
Yeah, I mean, once you get out and you can go in some of the
Mhm.
1950s cars or the little.
Right.
We actually jumped into, what do they call it? The Coco?
The Cocos, yes, those
Yeah,
little
one of the
taxi
little
type
yellow Cocos.
things. The Coco, yeah,
It's like
yeah.
a motorcycle with two seats in the back, and
Right,
yeah,
exactly. And a kind of a, I don't know what you call it, kind of like a covering, that's kind of weird, but
yeah, it's like
yeah.
a little. It reminded me of like the Tilt-A-Whirl at the
Oh
fair.
yeah,
It's
that's a
made out
great
of
way to
fiberglass
describe
and
it.
sort of
Yeah,
covers you like this. And
great way to describe it. Yeah,
yeah,
yeah.
yeah, that was really cool. Okay, so what are in the last few minutes that we have here? Is there anything else that you want to say about like going to federal court or types of cases that you take? And also, if you could share with us the jurisdictions uh, that you're licensed or admitted in. So if somebody's out there and they're listening to this and they're like, oh, you know what, I've got an N400 just like that, but I'm too scared to do it myself because I don't want to blow up my reputation in the first 10 seconds of practicing in federal court. I want to co-counsel with someone or get some advice, so that we can, maybe reach out
Right,
to that.
right.
So
So the districts I'm admitted in, I have a list because through the years I've had to get admitted in different places because cases come up. So offhand, obviously the District of Michigan, Eastern District and Western, District of Maryland, and Southern District of New York. That I remember the circuits, the 11th, the 6th, the 2nd, I believe, the U.S. Supreme Court. And I'm sure there are others, but those are the ones I can remember offhand. But I think in your list, I put where all the places I was admitted. As for cases that I take, anything that's challenging, that's immigration related, I'll take to federal court, as long as we have a strong case. And so here comes my 2 cents worth of advice, right? Make sure your complaint is rock solid because you can get dismissed for failure to state a claim. And if your complaint's weak, that's going to happen. So you want to do a really good complaint. I mean, some of my complaints are 20, 30 pages long. So you want to hit every point you possibly can. And that's where the research comes in and talking to others, because you want to hit every law that they've violated by doing what they did. So I throw in the APA a lot, and it may get dismissed on the APA, but then I've got another section. I've got injunctive relief, something I can go to, so you want to throw in as many as there to increase your chances. Always expect a motion to dismiss. That's the first thing they file. So be ready to respond to that. And I do my complaint. I've never done a trial. It's never gotten to that point, but I do my complaint in looking at, if I have to go to trial, what do I have in here? Because you're kind of bound to that, right? Very few cases are you going to have discovery just because they're going to settle or they're going to be resolved on the motion to dismiss. But if you get past the motion to dismiss, then you get discovery and you have summary judgment motions. So right now I have a really interesting denaturalization case where we got past the motion to dismiss from the government, and so discovery was allowed. And there is nothing like deposing USCIS officers. It's totally great. And always do a 30v6 deposition, because then the government has to produce somebody that can answer for the entire department. And in this one, I wanted the person in charge of basically USCIS. And they fought that so hard because they know that whatever that person says binds the entirety,
is
case
that
up.
our buddy Ken Cuccinelli?
Yeah, right. He didn't come. They designated someone else when the judge told them she's entitled to her deposition, that they fought so hard. And he sent a designee, and we got some really, the issue in my case was fingerprints, and it was back from the 90s. And so I remember those days when anybody could take fingerprints and, you just turned them in. And so that was the issue, the chain of custody of the fingerprints and the accuracy. And so in the 30D deposition, they admitted they had no control over the fingerprint cards back then. They didn't know what was going on. And that was really awesome to get that.
Wow.
Yeah. So discovery is a lot of fun. The only other time I've done discovery before is every so often I will take an illegal reentry case if we're going to do the asylum hearing afterwards, or withholding hearing afterwards. I'll do the federal stuff. So I'll take basically the whole package. I always ask for the A file. And that's pretty much the discovery you need in those cases to check if, in fact, the person was deported properly or removed properly or found excluded properly, depending on when, the incident happened. An interesting story about that is I got to court and I didn't get the A file. And so weeks had gone by and I called the U.S. attorney and she said to me, I can't get it from them. They're not answering the phone. When they answer, they'll tell me they're going to send it. I can't get it. So I said, okay, I'm going to do a motion for contempt. And she said, yeah, maybe that'll wake them up. So, and that's the difference, So I do a motion for contempt and it was before Judge Hood in the Eastern District. And she said, if she doesn't get the file by Friday, I want every ICE officer that's been through with that file or gone through that file in here because I'm holding them all in contempt. And then she said, Ms. Pastor, you call me at 9:00 Friday. And if you don't have the file, I'll see everybody here at 10. Got the file on Thursday.
All right.
Yeah. So discovery works, and that's another fun part of federal court is that you have access to everything. You're going to get what you need. And it's a good time to get things from files and, whatever else you think you might need in the future, because you will get that.
Do you ever pair one of your cases with a FOIA request?
Years ago, I did a FOIA, just a straight up FOIA, but normally no, because since you get discovery, if I don't have documents that I need, I'm going to ask for them in discovery. And the judges always, they set timelines for discovery, usually after the motion to dismiss. So you're going to get it, but you can ask for it before. And I find that the U.S. attorneys, the assistant U.S. attorneys are excellent in providing what they do have. So you never have an issue. It's a very collegial atmosphere, I could say, with the assistant U.S. attorneys. If you ask them for something and they're reasonable, like you said, when, in that one case you were discussing, you guys went out and they said, well, let's do this instead. That's what they're like. They're very collegial. They just want a result. That's fair.
Yeah. The whole point of even bringing that up was because I know that there's a lot of attorneys now really looking closely at federal court and saying, we're going to start doing this. We have to.
Yes.
When you get there, just remember, these are not ICE attorneys.
No.
These are not an administrative agency. These are people who you probably went to law school with.
Right.
Or people went to law school with.
Right.
And they're professional. Yeah. And my experience has always been very positive. Yeah. So it's good to go into that with that, like you said, a collaborative mentality to some degree. And there may be points that you just can't collaborate on that you let the judge figure out.
Right.
It's sort of what I saw. Oh, go ahead.
Sorry, but even that's done in a cordial way. We're going to agree to disagree and bring that to the judge. And in the denaturalization case right now, we have a disagreement over reopening discovery. And so we're going to take it to the judge and let the judge decide what happens. But, we're still talking. It's not like, oh, you don't agree with me, too bad, blah, blah, blah. No, it's still a very cordial relationship with the assistant U.S. attorney on that case. And it's just, they have their position. We have our position. Let the judge decide.
Which is, of course, completely, in many cases, not always, but many times, there's sort of an attitude in immigration court at the trial level at EOIR where, are you kidding me? Are you telling me that you never, ever, ever beat your husband? You're trying to tell me that?
Right. Yeah.
It's like, excuse me, first of all, stop your badgering. Second of all, if you're going to call him a liar, just call him a liar.
Yes.
Third of all, what is going on? Because this is ridiculous. Where's the decorum here?
Right. Oh, no, never. And I have to say that my practice is national. And so the different immigration courts that I've been, there are some that are better than others, but predominantly that's the kind of attitude you get from the ICE attorneys. Absolutely. Yeah. Very combative, very, trickery, all of that goes into how they practice, which you don't see in the federal courts at all.
Yeah. And I always like to think that there's typically two types of attorneys out there, right? When we were doing a lot of family law cases, like straight up divorce and child custody, things like that, either you get an attorney on the other side who is, or maybe it's you or me, right? Who take the position that, no, we're not negotiating on anything. We think you're a terrible person and you represent a terrible person. So it's like they try and make it personal against the attorney.
Right.
But then there's the attorneys who are like, all right, it's just you and me now. We're good. Hey, here's the deal. Here's how I see this going down. I think the judge is going to rule this way on that. What do you think? No? Okay. Well, we'll let the judge decide on that. How about the property division? We got a TV, we got a couch, we got a sofa, we got some child custody issues. Let's try and hammer those things out. The things we don't agree on, we'll leave it to the judge. We'll call it a day. And it's like, that's why those people don't get burnt out so easily.
Exactly.
Because they can separate it. Like, now, of course, in front of your client, you want to be professional, and maybe you're the bulldog type attorney who needs to be that in front of your client. But if you can at least work with the other attorney, I mean, unless your goal is to run up a bill, then you can really get through it and you can maintain that mental sanity at the same time.
And you know what? The judge puts a stop to that kind of behavior in the federal court. I remember in another district, there was an attorney that was working with some division at DHS and had gotten hired in as an AUSA, and it was the first day. And I had filed an emergency habeas in that district, and the judge we drew was awesome. And they had filed a motion to dismiss that morning on an emergency habeas. And so when we came in, they apparently thought they were still at DHS where, we do whatever we want and we don't care, and started arguing with the judge about having the motion heard that day. And the judge said, well, Ms. Pastor hasn't seen the motion. I haven't read it. So I'm going to give her a week because it's an emergency habeas. And the attorney said, no, but I'm ready to argue it right now. Blah, blah, blah. And the judge just looked at him and said, what part of I'm going to give her a week because it's fair don't you understand? And you don't want that from the judge ever. So, yeah.
Yes,
so
Your Honor. I agree.
Right. Yes. Whatever you say. Exactly. And that's the difference, that, you cannot go in with that behavior because the judges will put a stop to it, whoever's doing it. I mean, if I had approached it like that, then yes, I would have, I would have gotten yelled at or reprimanded. They're very serious about their rules, and that brings me to another thing. All the judges have their own separate practice guidelines. So you always want to look at those, because you want to look at obviously the federal rules of civil procedure and have those down pat. But then you also want to look at their individual practice. Some judges want you to send paper copies after you file electronically. Others want you to send 2 paper copies after you file electronically. Others want you to send it in a Word, email it. So you got to look at those things because those are really important.
Yeah, so it sounds like there's a lot to stay on top of in every jurisdiction.
Yes.
Yeah. Best practice, probably every time you take a case, review those for the case.
Absolutely. Every time I take the case at whatever district I'm in, I go ahead and review the local rules and the judges' guidelines, because those are really important. And they change from time to time too. So that's why I do it every time I take a case. I may have, been in this court 10 times, but before that judge 10 times, but I'm going to read it again.
All right. Well, Carrie, thank you so much for joining us today. I've learned a lot. I feel a little more confident in bringing stuff in federal court, and I definitely know some things to look out for. For anyone listening, you can find more information about Attorney Pastor. I said pastor before, but now that I know you're from Havana, Pastor.
Said that perfectly.
Spanish pronunciation. At pastorandassociates.com. More information about her. I'm sure she has a list of different jurisdictions she's admitted to there. And if you have questions about if she's willing to co-counsel, things like that, please reach out. That's how we do it. That's how we can start holding immigration to task, is by going into federal court and just shining some light on the subject. So thank you so much for joining us today.
Well, thank you for having me.